Well, most of you would know my name is Alan Palm. I'm not doing this video for anyone in particular. This is my way of keeping records of my inventory. Well, let me explain what is happening here. I have been in California for the past 5 or so years, and I have filed 2 matters in the District Court, the Federal Court of the United States of America, as a pro se litigant, meaning that I was representing myself. And I noticed there was some dishonest act going on. And there's this lawyer in California by the name of Richard Damian Ross, who was hired by St. Vincent and the Grenadines Prime Minister to cause me to trouble in California. So what I noticed was happening is that when I file a matter in the federal court in California, the judge will stay before he reply, like months, sometimes 2 weeks. But the reply is based on 2 things. One, if I have stated a claim in my complaint that was submitted, they wait until 2, 3 months, sometimes 4 months, until lawyer Richard Damian Ross crooks were able to steal my bags or get into my personal property and remove the complaint. And what they did, Richard Damian Ross would have his people in the district court take the complaint out of the judge's desk, or the judge will just replace it with the one that he gave him, because I strongly believe that the judge was involved in these behaviors, and they will change the complaint on the system. So when I go and print a complaint out of the system and I read it back, it was not the complaint that I prepared. You understand? So therefore, I can't go and say this is the wrong complaint because they have already stole my copy of the complaint. And therefore, I can't go and say this is the copy of the complaint that I filed in the court, and this is different from that which you have on the website. This is different from which the judge have on his desk. So today I went to the Superior Court and I filed a civil action, and this is how I'm going to secure myself. I am going to read the entire complaint on video, post it on social media, in order to protect myself from the dishonesty of Richard Damian Ross and all of the people that he has employed with him. Now, this is the complaint. It is beautifully handwritten in my beautiful handwriting. Why I handwrote this complaint was because Damian Richard Ross has a lot of hackers at his disposal, and most of them, a lot of them are black, but most of them are white. And the fact that a black man come to California and is willing to fight the system, is willing to fight against those people in the the Freemasons, for which Richard Damian Ross is affiliated, they are afraid that other black people will see me fighting like this and with this vigor and become active in their own welfare. So all he had to do is call up his white friends, and they rush and they would hack my phone, hack whatever I have, change documents, stop me from, man, these people. I will be typing a document here, and while I am typing, they are editing the document. That is how good they are. If you're not online, they will bring their own hotspot, sneak into the back door of your system, whether you're using a Dell, a Toshiba, Apple. They know how to get into the back door, activate your Wi-Fi, and take control of your system. So this is my defense for that. Now, the name of the complaint is Alan H.F. Palmer. My address on the top line it shows that confirm copy original filed, and it was filed on May 14, 2019 by Christina. I can't pronounce that. It is too small for me to see. I am getting old. That is the official file there. Now, the case number is 19-STCV16664. Jury trial is demanded. It's a personal injury. The cause of actions are professional negligence, negligent per se, vicarious liability, and negligent infliction of emotional distress. The plaintiff in this matter is Alan H. Palmer, that is me. The defendant in this complaint is Jorel D. Sommers, a medical doctor, Dario R. McDonald, a medical doctor, an unnamed defendant who is a pharmacist, UCLA Medical Center, Santa Monica, and the Santa Monica Medical Plaza Pharmacy. Those are the defendants in this case. And this case is a civil unlimited case. Page 1, line 21. Plaintiff alleged that defendant Jorel Sommers is at all times mentioned in this complaint is employed in the county of Los Angeles in the state of California. Paragraph 2, line 25. Plaintiff alleged that defendant Dario R. McDonald is at all times mentioned in this complaint is employed in the county of Los Angeles in the state of California. Page 2, paragraph 3. Plaintiff alleged that defendant, the UCLA Medical Center Santa Monica, is a non-profit corporation duly organized and exists under the laws of the state of California, with its principal place of business being the city of Santa Monica in the county of Los Angeles in the state of California. Plaintiff alleged that the unnamed defendant is employed in the county of Los Angeles in the state of California. Plaintiff alleged that defendant, the Santa Monica Medical Plaza Pharmacy, is a corporation duly organized and exists under the laws of the state of California, with its principal place of business being the city of Santa Monica in the county of Los Angeles in the state of California. The jurisdiction. Jurisdiction is proper in California's Superior Court for Los Angeles as per California Code of Civil Procedure, section 410.10. The venue. The venue is proper in the Los Angeles County in the state of California. Pursuant to the page 3 continue, California Code of Civil Procedure, section 392, all defendants' work or primary place of business are in the county of Los Angeles, the place of the incident. Introduction. This complaint is a civil matter brought by plaintiff Alan Palmer against 2 medical facilities and against 3 medical professionals. Defendant Jorel Sommers is a medical doctor who is employed in the capacity with the UCLA Medical Center Santa Monica for prescribing for the plaintiff with 1 kidney amoxicillin 500 milligrams and naproxen 500 milligrams, a potentially deadly combination when taken together, even more deadly for a person with 1 kidney. Plaintiff alleged that defendant Sommers was professionally negligent in his practice. Defendant Dario McDowell is a medical doctor employed in the capacity at the UCLA Medical Center, Santa Monica. Defendant McDowell was negligent in his failure to correct Dr. Sommers' mistake immediately upon discovering the mistake. Dr. McDowell failed to inform plaintiff that a mistake was made as is required by the Joint, page 4, Commission on Accredited Healthcare Organization. Plaintiff alleged defendant McDowell was professionally negligent and negligent per se. The unnamed defendant, in this case identity is unknown. Defendant is a pharmacist and is employed in the capacity at the Santa Monica Medical Plaza Pharmacy. The defendant failed in her obligation to the plaintiff by not informing him of the danger of each medication or the danger of taking both medication together. However, defendant handed over to the plaintiff via the cashier a deadly brew as the prescription instructed without warning plaintiff of the danger. Plaintiff alleged the unnamed defendant was professionally negligent. Plaintiff alleged that the defendant, the UCLA Medical Center Santa Monica, allowed their facility to be used by one who refused to act with the level of professional care to keep patients safe. The defendant also failed to provide the level of, page 5, on-the-job supervision the defendant Sommers and McDowell needed to consistently maintain the level of professionalism and professional care of the standard of such a facility. Plaintiff alleged the defendant UCLA Medical Center Santa was therefore complicit in its negligence and must deal with vicarious liability. Plaintiff alleged that Santa Monica Medical Plaza Pharmacy allowed their facility to be used by one in a professional capacity who failed to live up to their professional obligation to the plaintiff. The defendant, the Santa Monica Medical Plaza Pharmacy, failed to provide the appropriate level of on-the-job supervision. The defendant employee, unnamed, needed to consistently maintain a level of professional care that is required and expected, an expected standard of such a facility. Plaintiff alleged that defendant, the Santa Monica Medical Plaza Pharmacy, is therefore complicit through their negligence and must deal with vicarious liability. Page 6, plaintiff information. The plaintiff is a political asylee. He is also a New York State trained and certified emergency medical technician and EMT. Plaintiff is also a University of the West Indies trained and certified addiction counselor, of which pharmacology was one of the main course. Plaintiff is not or does not claim to be an expert in the field of pharmacology or emergency room practice and or procedure, but has a great understanding of the same to recognize certain irregularities and removal from common practice and procedure. Plaintiff is not an expert in pharmacology. However, plaintiff has a very good understanding of how medication works, such as diagnosis, half-life, etc. The facts are as follows. On the morning of Wednesday, the 5th day of September 2018, at 9 a.m., plaintiff went to the UCLA Medical Center, which is located in the city of Santa Monica at 1250 16th Street in the city of Santa Monica, Los Angeles, California. Page 7. In the county of Los Angeles, in the state of California, with a complaint of oral pain. Plaintiff was seen, booked in, and triaged. While plaintiff was in triage, he informed the nurse that he has one kidney, as he often do when in a situation where diagnosis and treatment is required. Plaintiff always make verbal disclosure about his kidney situation priority, because plaintiff knows how vulnerable his health is having one kidney. Plaintiff had first-hand experience and knowledge of the physical restriction, discomfort, and the expense that is associated with kidney failure. Plaintiff's close friend and colleague, Earl Pope, experienced kidney failure, which he died from. Plaintiff was confident he was in good and safe medical hands. Let me read over that. Plaintiff was confident he was in good and safe medical hands at the UCLA medical facility. The name, that is page 8, the name UCLA give the impression the facility is a teaching hospital and therefore is synonymous with a high level of care and supervision and supervisors who demand such. Plaintiff was confident the doctor, nurses, and other medical professionals on staff would be extremely careful. Therefore, plaintiff was at ease at the facility and with the professionals. Plaintiff oral pain was centered in a small area of his mouth and was coming from the gum. Plaintiff also informed the triage nurse he had a slightly elevated blood pressure, which the triage nurse confirmed after she took his vital signs. The vital signs are the body temperature, the pulse rate, the respiratory or breathing rate, and the blood pressure. Plaintiff has had no reason to question the level or the standard of care of the professional at that page 9 that practiced at the UCLA Medical Center, Santa Monica. When asked, plaintiff give the level of his pain on a scale from 1 to 10 as an 8, understanding that the question is comparative to the pain experienced prior. Plaintiff was stabbed in the abdomen with a knife. Plaintiff had an umbilical hernia that saw his intestines trapped in the opening of the hernia. All extreme painful experiences. Plaintiff had to endure the actual tearing of his abdominal wall in the process. Therefore, the plaintiff gave the level of his pain he was experiencing as 8. It was severe pain. The examination of plaintiff by the defendant Sommers on his first visit to the hospital was going as expected. Defendant Sommers began by asking plaintiff investigative questions in order to find out what was his complaint. Page 10. Defendant Sommers positioned himself and sat immediately in front of him, as was expected, as he listened to plaintiff complaint. Defendant Sommers then proceeded to examine subject mouth without putting on a glove. Defendant began pushing at the area, examining the tooth in the general area. At the time, plaintiff's main concern was the relief of the pain, but plaintiff was aware of the fact that there was a breach of sanitary health protocol. Defendant Sommers' unsanitary act caused him to begin to question the level of care and the professionalism of the institution. Medical protocol requires a doctor or a nurse to wear a glove when examining a patient. When examining a patient requires personal contact. This protocol is for the protection of the patient as well as for the professional. This practice limits the transmission of pathogens, page 11, to and from both parties. When defendant Sommers completed his examination and diagnosis, he did not discuss his professional findings with plaintiff. Defendant Sommers told plaintiff there is not much he can do except to give him something for the infection and something for the pain, and requested he see his primary health care provider and my dentist. Upon discharge, I was given a prescription of 500 milligrams of amoxicillin and 500 milligrams of naproxen, and my discharge paper with an official diagnosis written on the paper. Plaintiff discovered the doctor's conclusion or diagnosis was gingivitis. He was not worried, for gingivitis is a common childhood Caribbean disease which is treated by rinsing the mouth with high concentrate salt water and an aspirin for the pain. This worked very well. 12, page 12, plaintiff was seen by Dr. Sommers, who examined him but did not treat him on site. However, defendant Sommers discharged plaintiff with a prescription and the instruction to see his primary medical provider and dentist. And on page 12, there is a picture of the discharge forms. Page 30. On leaving the medical facility, the Doctor Unsanitary Act troubled him. He was fearful that he had contracted some second-hand disease. In an effort to get relief from the pain, plaintiff went to the pharmacy on the other side of the street, the Santa Monica Medical Plaza Pharmacy. The Santa Monica Medical Plaza Pharmacy is located at 1260 15th Street, Suite 100, Santa Monica, California, 90404. The prescription was filled by the pharmacist on duty and handed to me by the cashier, who I also handed the doctor's order to the pharmacy. The cashier asked me if I had any questions for the pharmacy. I did not have any concern about the medication because if there were any real or immediate danger to the plaintiff, the pharmacist has a professional obligation to bring said danger or concern to the client's attention. Plaintiff's concern at the time was pain. Page 14. Plaintiff asks the question through the cashier as to if it was okay to take the medication that was dispensed on an empty stomach. The cashier asks the question. Then that's the end of page 14. And here we have the doctor's discharge prescription. page 15. She relayed the answer to him. Then the answer to the question was no. Plaintiff had a chocolate drink in his possession and then donned the drink and took the medication as prescribed. Plaintiff walked 4.5 blocks then to discover that he had an overwhelming desire to urinate. Plaintiff unlawfully relieved himself by urinating behind a trash can. The trash can next to the 17th Street Metro State train station. About 15 minutes later, plaintiff felt another need to urinate. Plaintiff got off of the train at Exposition Boulevard and La Brea in order to unlawfully urinate outside the Metro property. While in the trip to downtown Los Angeles, plaintiff felt another overpowering desire to urinate. However, plaintiff held the desire until he reached the downtown area. It was a 45 minutes trip from Santa Monica to downtown Los Angeles and a 15-minute walk from the pharmacy to the 17th Street Metro train station. Within the hour, plaintiff realized there was no relief in the pain. As a result, this resulted in plaintiff taking another naproxen capsule to try to get some relief. 1/2 of an hour after taking the second dose of naproxen and an hour and a half after taking the first dose of naproxen, the painkiller prescribed by the defendant Sommers, plaintiff decided to research the medication. Through his research, plaintiff discovered that naproxen is a painkiller that is recommended for mild pain. He was shocked when he discovered the side effects of naproxen that was warned by the manufacturers are hypertension, blood clot, heart failure, and heart attack. It is important to note there are many over-the-counter drugs that are stronger than naproxen that do not carry the dangerous, page 17, side effects that naproxen does. A doctor will recommend or prescribe naproxen if the drug has additional therapeutic value to treat the illness. Other than that, the doctor will prescribe a less dangerous drug with less dangerous side effect. In the case of the plaintiff, naproxen had no therapeutic value to treat gingivitis, the ailment defendant Sommers diagnosed plaintiff with. The stunning revelation created by the findings of plaintiff research inspired the plaintiff to do further research on amoxicillin. Plaintiff was shocked when he discovered that amoxicillin is a strong antibiotic of the penicillin family and is used for treating potentially fatal systemic infection. The use of amoxicillin to treat a simple, localized oral infection such as gingivitis goes against manufacturer and amoxicillin researchers' recommended purpose of use. Amoxicillin has the following side effects, which are It affects normal kidney function as well as it affects normal liver function. Manufacturers and researchers advise against giving these drugs to patients with liver and kidney deficiencies. Manufacturers and researchers also recommend regular kidney and liver function tests should be administered to anyone who is taking amoxicillin. Defendant Sommers ordered plaintiff to take these two medications in volumes of 500 milligrams, while there was smaller dosage he could have given. A smaller dosage would have had limited the impact on plaintiff's body. Defendant Sommers also ignored common and standard observation protocol that are in place to protect patients from unwanted, page 19, medical injuries and death.